Yes, here we can recall that the ATF's so-called purview over our right to keep and bear arms is not sanctioned by the U.S. Constitution, but a strong understanding of this Trump administration change is important. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and principled Americans might recall that circa 2018, Ms. Bondi and Mr. Trump appeared side by side at a press conference in which they extolled the virtues of her efforts as then Florida Attorney General to execute the equivalent of red flag gun grabs, or what she termed gun violence restraining orders, on people who hadn't been granted due process, had not been convicted of any crime, and are by definition as human beings who supposedly possess the right to keep and bear arms, supposed to be unmolested by government goons.
And we are going to bring in something called the gun violence restraining order. So if someone is civilly committed, typically you can hold them for up to 72 hours, but people are getting out within 24 hours, the majority of them. So what we want to do is let law enforcement come in and take the guns.
Good.
They're a danger to themselves.
Which you can't
or
do
others.
right now.
Well, because without being adjudicated. So because they're a danger to themselves.
You want them to take the guns and
when they are
not go through 6 months of legal trials and everything
exactly.
else.
Well, Mr. Trump's triumphal enthusiasm at the time alarmed many traditional conservatives who saw him nod as she blissfully promoted the idea of government agents engaging in towering attacks on the Second Amendment, the Fourth Amendment's prohibition against unwarranted searches and seizures, the Fifth Amendment's prohibition of government depriving people of life, liberty, or property without due process, the Sixth Amendment's promise of a speedy trial by a jury of one's peers, the right to face one's accusers, and the right to call witnesses for one's defense, the Eighth Amendment's prohibition of cruel and unusual punishment. Of course, how can one be punished if one has not been accused of a crime and put on trial? And the 14th Amendment's reiteration of due process. Mr. Trump added to the frustration and alarm by issuing in his first term unconstitutional so-called executive orders, through which he attempted to ban bump stocks and pistol braces. But now, both Mr. Trump and U.S. Attorney General Bondi seem to be singing a different tune, a pro-gun rights song that comes to us as the changeable winds of political expedience seem to blow in a similar way. Reason's Jacob Sullum reports that Trump's AG issued a new interim final rule pertaining to convicted and released felons who, since they've been released and deemed safe enough to be in society, are supposed to be able to exercise their gun rights. But they've been prohibited by government. In fact, it's a change that pertains to Donald Trump. Quote, although President Donald Trump has been entrusted with control of the nation's vast military might, including its nuclear weapons, he's not allowed to own a gun. He lost that right as a result of 34 state felony convictions involving falsification of business records. Whatever you think of the legally dubious case underlying those convictions, this situation makes no sense as a matter of public safety. It epitomizes the absurdly broad criteria that bar Americans from possessing firearms under federal law. End quote. And when Sullum writes of so-called criteria, he means unconstitutional federal statutes. Quote, under 18 U.S. Code 922 subsection G, prohibited persons include anyone who has been convicted of a crime punishable by more than a year of incarceration, regardless of the sentence that was actually imposed, whether or not the offense involved violence, and no matter how long ago it happened. This is the provision that forced Trump to give up his guns, even though his offenses were non-violent and did not result in any formal punishment. The law also prohibits gun possession by anyone who has ever been subjected to involuntary psychiatric treatment, even if he was never deemed a threat to others. Anyone who defies these bans is committing a federal felony punishable by up to 15 years in prison. He could face additional penalties for lying on the federal form that must be completed to buy a gun from a federally licensed dealer, which can be construed as two distinct felonies under U.S. Code 922A6 and U.S. Code 924A1A, and for trafficking in firearms, which Congress has counterintuitively defined to include prohibited persons who obtain guns. All told, a prohibited person who dares to exercise his Second Amendment rights could face combined maximum sentences of nearly half a century. End quote. And isn't that lovely? Yes, you know, perspicacious Americans likely notice in those federal codes blatant attacks on the Fourth Amendment via an invasion of privacy at the point of purchase and attacks on the aforementioned Fifth Amendment's prohibition against seizure without due process. No due process is afforded if the government engages in a priori restraint of a right. Sullum adds, quote, under U.S. Code 925C, someone who loses his gun rights can ask the Attorney General to restore them. The Attorney General has the discretion to do that based on a determination that the circumstances regarding the disability and the applicant's record and reputation are such that the applicant will not be likely to act in a manner dangerous to public safety and that the granting of the relief would not be contrary to the public interest. But that responsibility historically has been delegated to the ATF, which Congress has barred from considering such applications. End quote. Yes, here we can recall that the ATF's so-called purview over our right to keep and bear arms is not sanctioned by the U.S. Constitution, but a strong understanding of this Trump administration change is important. Writes Sullum, quote, Attorney General Pam Bondi recently took an important step toward addressing the unjust, constitutionally dubious burdens imposed by that policy. An interim final rule that took effect last week aims to revive the moribund legal process for restoring the Second Amendment rights of prohibited persons who pose no threat to public safety. The rule rescinds the delegation of that process to the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, which Congress has long prohibited from accepting applications for relief. End quote. In other words, the ATF had been given the power to review the applications, but Congress prevented that from happening. As a result, the practical outcome for many Americans in this dubious limbo state, well, it's been, of course, obstruction of their right to keep and bear arms. Quote, Bondi says reasserting the Attorney General's authority to implement Section 935C is consistent with Trump's February 6th executive order protecting Second Amendment rights, which instructed her to examine all orders, regulations, guidance, plans, international agreements, and other actions of executive departments and agencies to assess any ongoing infringements of the Second Amendment rights of our citizens. End quote. But the larger rights and logic problem persists. If a person is deemed safe enough to be out of jail, why is that person not safe enough to exercise a God-given right to keep and bear arms? And if that person is not safe enough to keep and bear arms, why is he or she out of prison? And if that person is not safe enough, will a government proscription of him legally owning a gun stop him from acquiring one on the black market? And how does this new stance comport with Bondi and Trump's previous affection for clear attacks on gun rights via red flag statutes? The upshot of these questions is that any collectivist system of so-called policing and protection will see an ever-permutating set of government players and citizens trying to impose their disparate views on how the justice system is to be run. But the founders made their disputes moot. Unless the U.S. Constitution is amended, the Second Amendment is clear. No level of government shall prohibit the right to keep and bear arms. That's supposed to protect everyone's right, be he a person with no criminal record or someone who has been released from prison, or, like Donald Trump, a person who has been through myriad court cases, been convicted, and never been unceremoniously thrown behind bars. Bondi's move is a good first step, but it's a step that need not be taken if the U.S. government would simply abide by the Constitution. Thanks for watching, everyone. Please like and subscribe. Share these with people you think might be interested in this sort of history and information. Of course, find us at Rumble, where they don't censor us. Find us on YouTube, where, yes, sometimes they do censor us. Find us all the time at MRCTV.org. That's MRCTV.org. Please check out the store and consider donating. Find us on Instagram. Find us on TikTok. Find us on X. And if you want to find me on Gab, I'm at Gardner Goldsmith. And on X, I'm at Gard Goldsmith. Thanks for watching. For MRC TV, I'm Gardner Goldsmith.